And good morning, everyone, and welcome to this week's Let's Talk. And today we're going to be doing just that. We're going to be talking about the province's Adult Protection Act, and I'm looking forward to a really good session. Our weekly Let's Talk is sponsored by United Way, Newfoundland and Labrador, and we're very, very grateful to them for that sponsorship. Without them, we may not even be here. Before we get going, I just want to do a few, why is it not working properly? So sorry, technical difficulties again. I don't know why that isn't coming up. I'm going to go out. Aha, here we are. Finally. A few housekeeping issues here. As I mentioned, please keep your mics muted unless until you're ready to speak at the end if you have any questions or anything. As captioning is at the bottom of the screen, I think everyone can see that. We also have sign language interpreters with us today, so you can put on your multi-link. I think I got that wrong, but anyway, those of you who use sign language interpretation will know how to see the two ladies with us. Any questions or comments you have, I'd really appreciate it if you put it in the chat box at the bottom of the bottom right of your screen. And as you know, this session has been recorded. And one final thing, if anyone has any requests for presentations, if there's something that you would really like to us to have discussed or presented on during one of these weekly Zoom sessions, just let me know and we will certainly give it every consideration. I'd like to pause now for a couple of minutes so we can acknowledge the lands that we live on. We respectfully acknowledge the land on which we gather as the ancestral homelands of the Beothuk, whose culture has now been erased forever. We also acknowledge the island of Tikomatkoka as the unceded traditional territory of the Beothuk and the Mi'kmaq. And we acknowledge Labrador as the traditional and ancestral homelands of the Innu of Nitassinan, the Inuit of Nunatsiavut, and the Inuit of Nunatukavut. We recognize all First Peoples who were here before us, those who live with us now, and the 7 generations to come. As First Peoples have done since time immemorial, we strive to be responsible stewards of the land and to respect the cultures, ceremonies, and traditions of all who call it home. As we open our hearts and minds to the past, we commit ourselves to working in a spirit of truth and reconciliation to make a better future for all of us. You remember when you registered, we asked a couple of questions there. And the first question, I just want to run over these stats for you. The first question was, have you heard of the Adult Protection Act? And not unexpectedly, 199 people of the 240 that registered have certainly heard of the Adult Protection Act. 8 people said no, and 7 people weren't sure. Okay, so everybody was going to get a refresher course now on the Adult Protection Act today. The other question, the second question was, do you believe that seniors have the right to take risks? There were 194 responses to that out of the number who registered. 190 said yes, and 4 said no. Seniors didn't have the risk. the right to take risks. It would be wonderful to be able to hear those points of view as we go on through the day. During pre-COVID days, Seniors NL staff, volunteers, and sometimes more often partners of Seniors NL spent a lot of time traveling around the province, giving presentations, facilitating training, workshops, etc. On a number of occasions, we invited our audience to complete a survey. And one of the questions we asked frequently was, do you think elder abuse is happening in your community? The no responses were dominant every time. No, there's no elder abuse going on where I live. Well, elder abuse, including neglect and self-neglect, is alive and well in Newfoundland and Labrador. There is certainly no doubt about that. Probably takes place in every community in the province. And today, our guest speakers will talk with us about a piece of our province's legislation intended to offer protection to a portion of the population considered to lack the understanding necessary to recognize that they're being abused or neglected. And now I'd like to present today's special guest, Henry Kielley. Henry is a social worker from St. John's, graduated with his BSW in 2000 and his MSW in 2008, both from Memorial University. Henry spent 10 years with Eastern Health working frontline in mental health and community supports, but mainly in long-term care. Henry managed the long-term care single entry program for a number of years before joining government in 2010. Henry has been with government since then, with the exception of a year spent as manager of social work and spiritual care in a long-term care facility in Manitoba. Henry now works as the Director of Seniors and Aging Division of the Department of Children, Seniors and Social Development, as well as Acting Provincial Director of Adult Protection. And congratulations on your new position, Henry. It's great, long overdue.
Mary, your slides aren't up. You haven't got it on slideshow?
Sorry, you're not seeing the slides?
Yeah, the slides are there, but you haven't got the slideshow up. You haven't started it. So go to slideshow and begin. Because you don't see Henry's picture.
You didn't see Henry's picture?
No, you don't have your slide.
Sorry. I'm going to carry on though, okay? Our second presenter of the day is Steve Ross, and Steve is a registered social worker from Bishop Falls. He has a Bachelor's and Master's of Arts in Political Science and a Bachelor of Social Work from Memorial University. Steve has worked as a social worker with Newfoundland and Labrador Housing and with various community centres throughout St. John's. Since 2019, Steve has worked as an adult protection consultant with the Department of Children, Seniors and Social Development. And without further ado, I am going to hand it over to Henry now, or Steve, whichever one of you is going to come first. And once again, everybody, if you have any questions or comments, please click on chat and put it in the chat box at the lower right. Thank you.
All right, thanks, Mary. And I think you may need to stop sharing your screen so I can share mine.
Yep.
All right, so while Mary is doing that, just want to say good morning, everyone, and a thank you to the Newfoundland Labrador Network for the Prevention of Elder Abuse, for the invitation to come and join you today for this this talk about session. And I hope during these remarkable times of COVID that you're taking some time to actually practice some good self-care. We're going to be talking a little bit later this morning about the idea of informed consent. So also hoping during this COVID time that you have access to the information you need to be making the decisions that you need to be making at this time. So we are going to be talking about adult protection and capacity. Um, and the focus today will largely be on older adults. And we see that with adult protection, most of our referrals and cases so far have been regarding older adults. And I think that's partially a reflection of the population of the province. But the Act itself does apply to all adults in the province who are 18 and older. So just important to keep that in mind. This is a really important topic for all of us, and we'll get into more of the why as we move along. But while we're speaking, I guess, from the more narrow perspective of adult protection, the idea of capacity and the idea of risk and choice and autonomy are very broad and impact all of us. So no matter if we're a member of the public and we're in receipt of services, if we're a frontline clinician, if we're an educator, if we're a student, these concepts have implications for all of our areas of practice and all of our lines of work. So really it's about, I would think, developing collectively a community of practice here. It's not about one person or one program or one group of people having all the answers, but it's really about that shared responsibility. Again, if we're practicing to, keep our competencies sharp in this area, but also just generally as citizens, it's important that we be part of the conversation as well and contribute to that community of practice. Because again, it certainly affects all of us. And what I'm hoping is that this is going to be another piece. I was going to say conversation, but maybe that's not the right word because I'm just talking at my slides. But I'm hoping that this is going to be another piece of an ongoing conversation that all of us need to be a part of as this community of practice evolves. So before we actually get into the presentation, I'll just pause for a moment and see if Steve has any opening remarks as well.
No, would very much echo your thoughts, Henry. I think so much of adult protection and capacity is intertwined with risk and the rights of adults to exercise choice and how we can support folks to mitigate risk and exercise choice when there may be challenges from a capacity perspective. So I hope today's session can really highlight that piece of the conversation and how important it is in adult protection.
Excellent. No, that's great. So are slides changing for folks? Can people see the agenda? Yes? Okay.
Yes.
Great. So this is generally what we'd like to cover today. We'll talk a little bit about the Adult Protection Act itself, so the law, and just some of the service principles and ideas behind the concept of adult protection. We'll talk a bit about capacity. Capacity, again, the ability to understand and appreciate is the backbone of adult protection. And certainly a really key concept for all of us to understand. We'll talk a little bit about some of the processes around how we assess capacity, again, from the adult protection perspective. We'll address some of the FAQs that you've raised in previous sessions and as well during this session. And then just think about some next steps and what this discussion needs to look like going forward. We are in the midst of a 5-year review of the Adult Protection Act. Some folks may have been aware of or involved in a bit of a roadshow that Steve and I did, pre-COVID now, so it feels like 100 years ago. Just getting feedback on how the Act has been impacting folks in the province during the last 5 years. So we've gotten some really good feedback and looking at some potential amendments to the Act as well. So happy to answer as many questions as I can about that. And we'll be looking forward to future education sessions as we go. And then we will have a session evaluation. We always appreciate hearing what's helpful and not helpful about these sessions and what we can do to improve them and make them more effective. So I'm just going to pause there and I'll hand it off to Steve.
Great. So folks, just a little overview of the Act. So the Adult Protection Act is the law in Newfoundland and Labrador that protects the adult residents of the province who are at risk of abuse, neglect, and self-neglect, and who do not understand or appreciate that risk. So we'll discuss this criteria more for coming under the Act shortly, but this idea of understand and appreciate that really refers to the concept of capacity. And as you'll see, is very important in adult protection, and we'll of course discuss this in greater detail as we work through. The Act is also the legislative authority for the delivery of services to adults in need of protective intervention. So this means any services or resources or court orders that are completed for an adult who's abused or neglected and does not understand and appreciate the risk are done in accordance to this law. Under adult protection, folks, as well, we all have a legal duty to report abuse, neglect, and self-neglect, where a person may not understand and appreciate that risk. So a report can be received by a regional health authority, social worker, a manager, a director, or police officer as well. And that 1855 number, that is a provincial toll-free number, can be called from anywhere in North America. And the number will take you to the intake of your local regional health authority, who will take that information and screen the report and then determine whether an evaluation is merited. And reports can be provided confidentially as well. Folks, just want to highlight that as well. So all names of referral sources, of course, are kept confidential unless, for example, the disclosure of information could be required by a court, for example.
Steve, I'll just add, and I think we're both going to touch on this more later. It's not the job of the report source to determine someone's capacity. So if I'm worried about my neighbor, or I think there's something going on with a relative or whatever, it's not my job as that report source to determine if that person is capable or not. If you think the person is at risk of abuse, neglect, or self-neglect and may not fully appreciate what's going on, then you have to call.
Right, so folks, the Act was proclaimed in 2014, so relatively new still in law years, I guess, and it did replace the Neglected Adults Welfare Act of 1973. So this created a number of big changes. So for example, a big one was the inclusion of abuse, for example, in the Act. So that can take many forms and generally encompasses, along with neglect and self-neglect, forms that are often included in the province's violence prevention initiative. So that could be, for example, physical or financial, sexual, emotional, psychological, as well as verbal, and cultural and spiritual as well. And a big change too, coming from the Neglected Adults Welfare Act, is that it created this 4-step process that we're going to touch on more. We'll touch on this again shortly, but that process kind of came in with the Adult Protection Act. And of course, another big change that's relevant for today's discussion is the introduction of the concept of capacity, which of course we'll discuss in greater detail as we go through. Another important distinction to make as well, folks, is that the Act is operationalized by the 4 regional health authorities and administered by the Department of Children, Seniors, and Social Development. So this means that all reports, evaluations, and investigations take place at the regional health authority level, while CSSD, which myself and Henry Shop, is responsible for the administrative functioning of the Act, so around like policies and procedures and whatnot. It should also be noted, though, that the provincial director position, which in this case is Henry, also performs sort of a decision maker function. So in the event all options to mitigate risks have been exhausted and a decision maker of last resort, we'll say, is needed to mitigate the risk, an application can be made to court to declare an adult to be in need of protective intervention and to come under the care and custody of a director. And folks, the Act also created, as I alluded to just then, a 4-step process for supporting folks who may be in need of protective intervention. So this will be reporting, evaluation, investigation, and review. So we'll briefly touch on this process in subsequent slides, but helpful to note that this is a legislative process. It's used throughout the province, and there are legal responsibilities for various parties in those steps. And finally, folks, really important to note that the Adult Protection Act, we often refer to it as an act of last resort. So that is, folks are always looking for opportunities to not use adult protection, we'll say, and to take less intrusive steps to support folks. And this is really because it's recognized that the Act, if used to its fullest extent, it can be really intrusive and really interfere with a person's independence. So it's in that spirit that we have to say, it's almost like a dual commitment under adult protection to both protect vulnerable adults that may not understand or appreciate the risk, but at the same time uphold and strengthen the autonomy of those adults.
No, that's a good point, Steve. And we very much come at it in that spirit. So one of the service principles of the Act is that all adults are presumed to be capable unless, the burden of proof or evidence is on us as the system to substantiate that. And by the time something gets to court, we need to be very clear that everything else has failed to address the person's need or mitigate the risk. So we're always trying to work ourselves out of a job. So just to touch on the criteria, again, capacity is going to come up a lot. In order for this act to apply, the adult has to be found to lack capacity, and that individual is unable to care for themselves, so some type of self-neglect, or is abused or neglected. But underlying all of it is the capacity piece. And we're going to drill down a little bit more into that. And I know one of the questions that came out, I think from a previous session or related to this one, was the idea of capacity versus competency. So competency has historically been used in a lot of legal circles, but also in some medical circles, and generally applies to the idea of global mental ability. So the person is competent or not. When we think about capacity, particularly in relation to adult protection, we're talking about decision-specific capacity or domain-specific capacity. Is a decision related to health or finance or housing or any other kind of aspect of someone's care. So the person needs to be found to lack capacity in that particular area. And then we start the adult protection process. The Act does apply to all adults living in the province, regardless of where they live. So we've accepted reports from acute care, long-term care, personal care homes, community, alternate family care homes, independent living arrangements, you name it. Steve, I'll pass it back to you to talk a little bit about the process.
Sure. So in terms of how adult protection works, when a report is made, it's screened at intake by the Regional Health Authority to determine whether a report meets the criteria set under the Act that Henry just discussed. When a report is received, a risk level is assigned in accordance with risk continuum guidelines that have been developed. The risk can range from low to extremely high, and that risk level will determine the response time. So this response time can range from immediately to 5 clear days, depending on the area of risk. And there are a number of factors that could impact risk. For example, what is the allegation, or what are some of those protective factors, for example, like involvement from family or friends? And of course, what is the person's status in respect to capacity? So all those things are going to inform the level of risk and the response. If the report is accepted, it proceeds to an evaluation. So the purpose of the evaluation is to sort of just assess the situation and make determinations of risk and how it can be mitigated. So the role of a social worker here is very much like a healthcare provider. They're working with the person's consent. So they would be interviewing the report source, if possible. They would interview or observe the adult who may be in need of protective intervention. They're constantly assessing the level of risk. And of course, referring to police if criminal activity is suspected, and of course, gathering collateral information with the person's consent if needed. At the conclusion of the evaluation, there are generally 3, I would say, broad outcomes. So that could be, for example, it could be no further involvement. So, for example, the allegations may not be substantiated. Another option could be, of course, just the provision of professional or supportive services to mitigate the risk. Or it could proceed to an investigation. A quick point on the evaluations. So important to note that over 90% of our case of adult protection cases conclude at the evaluation stage. So I think this really speaks to the great work that gets done in the regions in supporting folks, sort of mitigating that risk in the least intrusive and restrictive way possible. But in the event it couldn't be, you can't mitigate the risk, oftentimes it proceeds to an investigation. So the investigation is very similar to an evaluation. However, a key difference is that we're operating without the person's consent. So the role of the social worker remains very much the same. So you're continuing to assess risk, or you're referring to police if criminal activity is suspected, or you're interviewing the adult. An investigation also has provisions around an ability to access records or speak with collateral sources, or interview folks that might have pertinent information. And it may also involve the coordination of a formal capacity assessment, which of course we'll discuss in greater detail. following the investigation, very much like the evaluation, there are general 3 outcomes. So again, there could be no further involvement. There could be a provision of professional or supportive services. Or the big difference at this piece, of course, could be that folks could make application to court to declare the person to be an adult in need of protective intervention. So this last step, as you would expect, is a last resort option, and it occurs very infrequently, as folks are able to mitigate risk in less intrusive ways. For example, maybe a substitute decision maker comes forward from a healthcare perspective, or maybe a support person comes forward, or maybe a safety plan is implemented, or so folks are always looking for those opportunities to mitigate the risk and kind of park the adult protection process. And again, this is really, again, as we alluded to, is recognize that the Act, if used to its fullest extent, so in this case, like a court-ordered declaration that places someone under the care and custody of a director, of course, it's extremely intrusive, should only be used if all the other options have been exhausted. But in the event an adult is declared to be an adult in need of protective intervention, this sort of initiates what we would say the 4th step of the process, so which is a review. So when an adult is declared, a service plan is developed with the adult to address the areas of risk, and the plan is reviewed every 6 months. And the Act has also legislated a review committee process that meets yearly to review all those service plans. And this review process, folks, is really important. It's not only does it kind of provide the opportunity to revisit those service plans, but I think it's also designed in recognition that capacity can change. And we'll get at this more in our following discussions, but the review process does provide that opportunity to review those plans and potentially revisit a person's capacity if necessary.
Steve, I'll just add, you talked about a dual role for social work. I think, and not just social work, but all disciplines, while we're assessing capacity, we're also supporting capacity. So if you think about the clinical or the therapeutic relationship that a clinician has with that adult, we're always seeking that mutual understanding and clarifying, and it's always that back and forth. And we're always facilitating that clarity, and we're always addressing those barriers to communication. So by the time it comes to, pass some kind of clinical judgment on someone's capacity, we're not starting with a stranger, and we're not starting with a blank sheet. So we're starting from somewhere. And, all relationships take time, and therapeutic relationships take time. And, I think it's important that we remember that. The other thing I'll mention, so we talked about evaluation and investigation. It all equals assessment. So we're always assessing risk. We're always trying to, do anything else but adult protection, put supports in place, provide services, link people with natural circles of care or what have you. And as Steve mentioned, in the evaluation stage, we're operating with informed consent. And there's that term again. So informed consent means that the adult is fully informed of what's happening, of what the potential outcomes are, of the right to not participate, of the implications of participating and not participating. So this is a large piece of work that needs to go into the whole informed consent process. I can't make an informed decision without information. And only I can determine what information I need to make that decision. And then it's the job of other folks to provide me with that information and make sure I have an understanding of it. So I think the term informed consent gets thrown around a lot, but it's a complex piece of work, and it's a really deliberate relationship building piece of work that needs to happen. And so in the evaluation stage, we are still operating with consent. If we can't mitigate the risk, as Steve says, we shift gears to investigation, still trying to involve the adult to the fullest extent possible. And so while it may not still be informed consent, we're hoping it's at least some form of assent, or at least there's no disagreement with what we're trying to do. All right, Steve.
Yes, so folks, and this is just sort of it's a decision tree that was created to highlight the adult protection process that we outlined. So very much just a visual representation of the process that myself and Henry just discussed. And folks, I think I found this to be a helpful tool for sort of like a quick reference when reviewing the adult protection process. Before we jump forward, I think just to reference another section of the Act, we do have the ability under Section 23 of the Act to complete emergency interventions. So in the event a case comes up where the risk of substantial harm is imminent and is believed that the person doesn't necessarily understand or appreciate that risk, there is an ability to remove that person from that situation to a place of safety. Of course, again, that process is rarely used. However, that ability is there if the risk is high and we need to sort of act to protect someone from that harm. And that process can also be applied to financial interventions under Section 24. So if there's immediate danger of substantial damage or loss of assets, there is that ability to intervene on an emergency basis there. But yeah, just thought that would be helpful to highlight that other piece of the legislation that might be interesting for folks. Anything to add on that piece, Henry?
No, I don't think so. And as you said, the decision tree is just kind of a visual quick reference. A lot of staff in the regional health authorities would have access to that. And it's just kind of a quick flow sheet or cheat sheet. So we just thought we'd share some statistics. And of course, we know that 87.5% of people enjoy statistics in slideshows. So we like to include them here for people's consideration. But I'll also warn you that 46.5% of stats are made up on the spot. So always be careful. So this is just some of the stats, just to give people a bit of a lay of the land. We receive about 90 reports per quarter. So that's from all 4 regional health authorities. About 80% of those reports concern individuals who are 60 years or older. And again, I think that's a reflection partially of the current demographic situation in the province. But again, the Act does apply to adults 18 and older. We see the most common allegations are neglect and self-neglect. And oftentimes an allegation or a report will have more than one type of abuse mentioned. And as Steve noted earlier, we've aligned the Act with the province's violence prevention initiative. So when we talk about abuse or violence, we do think about or reflect on the 9 different types of violence, from physical, emotional, cultural, and on it goes. So the highest sources of abuse, well, self-neglect is the largest allegation. So a lot of it is self-neglect, but then family members are the second highest reported source of abuse. And since the Act was proclaimed, we've conducted about 40 formal capacity assessments. And as we've been alluding to all along, a capacity assessment isn't something that we'd undertake lightly, because if we go down the road of that and we use the law to its fullest extent, we are essentially removing an adult's or part of an adult's decision-making rights or their autonomy. So we need to be very, very careful before we go down that road, because we all have inherent rights as human beings, as citizens of Canada, as citizens of Newfoundland and Labrador, under various charters and conventions and other documents that indicate how we will be treated. So to say that you no longer have the right to make decision A, B, or C is a big deal. So we need to be very conscious of that. So we've had about 1,400 reports, and as Steve mentioned, less than 10% of those have had to proceed to an investigation, which is excellent. All right, Steve, I'll pass it back to you to get us going on capacity.
Henry, I lost you on that piece, Henry.
Oh, whoops. I was just going to pass it back to you to get us started on the capacity side. Yeah.
Okay. So folks, the remainder of the session will focus mainly on capacity, of course. So before we even kind of go down that piece, thought it would be helpful to open up with some just general thoughts on, why capacity? Why do we always emphasize capacity? Why is it such a critical component to adult protection? Or, why is it such a big deal, I guess? And I think there's a couple of things to highlight here. I know Henry just touched on a couple of pieces with it. first, as Henry highlighted, I think all adults have that right to live their lifestyle they're choosing. So that's not something that's just embedded in the adult protection process. It's really enshrined in the, the rights and freedoms that we have under the Charter of Rights and Freedoms, for example. And not only do we have the right to live the lifestyle of our choosing, but we have that right to live at risk and make choices that folks may consider to be bad or unwise, for example. So those would be just fundamental freedoms that sort of apply across jurisdictions, really, in Canada. Yet, while we have those fundamental rights, we also recognize that there are times when someone could be at risk of harm and are unable to understand and appreciate that harm. So this dilemma, we'll say, like a protection and autonomy, this is sort of like just a fundamental, I think, ethical dilemma that we all struggle with. The concept of capacity is really used at finding that balance. Does this person understand and appreciate this risk? And if they don't, we as helping professionals have that responsibility to intervene to support and protect that person. So the concept is really about finding that balance and recognizing that the concept of capacity is sort of inseparable, really, from the rights of all individuals to sort of exercise choice and autonomy in society. And related to that, I think it's important that when we think about the idea of capacity, that we recognize that history is really important. I think while great strides have been made in this particular area, I think it's important to reflect on the idea that historically, many persons, including older persons and seniors, were in some contexts historically not given the same dignities of, we'll say, risk and choice that have been given to other folks under this pretense, as it was referred to as being, we'll say, incompetent to make a decision. And we'll touch on these pieces more as we kind of work our way through, but I think it's helpful to highlight this because it does provide context as to why I think so much emphasis gets placed on upholding a person's rights and practicing adult protection and capacity assessments from that sort of least intrusive, least restrictive stance, we'll say.
And Steve, to that point, we've certainly seen isms that come into play that are barriers to people's autonomy. So certainly ageism, ableism, racism, some of these other concepts that, we look at a person and presume they're not capable just based on, some kind of presenting characteristics. So capacity is a huge concept, and 2 bullets don't really do it justice, but essentially it is the ability to understand information regarding any decision related to us, certainly healthcare decisions in adult protection, and different domains that we see listed here, and the ability to not only understand, but also then appreciate the foreseeable consequences of a decision, or, as we said earlier, the lack of a decision. So can a person understand information, take that information, manipulate it, weigh it out, and then take the next step in appreciating? So it's really 2 steps, and one really can't go without the other. So it's really important that, as we talk about capacity, and certainly as we are involved in capacity assessments, that we consider both of those concepts. And certainly as we move through the review and amendments of the Act through the 5-year review, we see, and we heard loud and clear from practitioners, that there really needs to be more, I guess, a bit more structure and support and guidance and resources provided around some of this stuff. So we all have a better sense of clinical confidence when it comes to being part of these conversations. Steve, anything you want to add there before I move to the next slide?
No, that's great, Henry. No, that's good.
Okay. And sorry for flicking the slides earlier. I didn't realize that the wheel on my mouse was like just seeing if you're paying attention. So one of the things that we have learned in the first 5 years with the Adult Protection Act, and it's based on the principles of the Act and the approach that we take, there's really kind of 2 stages that we've seen to capacity assessments and the conversation. So one is the clinical assessment and the conversation that happens around the clinical determination of capacity and incapacity. Then with adult protection, really, it's not that that doesn't matter, but that is evidence of the person's potential incapacity that gets carried into court. And then a judge determines whether or not that person has legal capacity. So it's all capacity, but you can see based on the circumstance, it's interpreted or considered a little bit differently. And in our province, we have several pieces of law that assess and determine capacity, and they do it a bit differently. And it's not that they're right or wrong. Each was written in its own time for its own purpose. But depending on what piece of law is in play, a clinical determination of incapacity may be sufficient. So for example, I'm aware of cases under the Advanced Healthcare Directives Act, where a substitute decision maker may have been determined to not be acting in the best interest of the adult, and a health authority has stepped in and removed that person as substitute decision maker. Or a person has been determined clinically to not be able to make their own decision, and someone else needs to make that decision on their behalf. Again, that can happen under the Advanced Healthcare Directives Act. So that's more the clinical piece. But the legal piece is when a judge agrees with the evidence that's been presented and says that, yes, Henry is not capable in these particular areas. So what we're learning is that we need to be very careful in gathering our clinical evidence. And the lawyers will be very careful to tell me that evidence is not proof. Evidence is evidence. So it's that clinical evidence that the person may lack that capacity. And then again, it's that legal process. So in practice, and Steve kind of alluded to this earlier, what we've found sometimes, depending on the risk and the situation, is that while the circle of care may have determined that this person clinically lacks capacity, until we get to court in 2, 3, 6, or 8 months, and a judge agrees with that evidence, there's really no authority under that act to impinge upon that person's autonomy. So there's a need sometimes, again, depending on the level of risk, with the right checks and balances, that we need to intervene in an emergency situation. So we talked a little bit about capacity versus competency. And again, I would suggest to you, the analogy is more like a dimmer switch versus just a light switch. So competency is all or nothing, where capacity is more of a continuum. And it certainly is fluid. And we know that there's a lot of things that can impact capacity. Certainly mental illness, diagnosis of dementia. All of these things can influence someone's decision-making ability, but it doesn't necessarily mean the person can't make decisions anymore. So it's very important to come at it from the point of, from a rights perspective and from that point of autonomy. And courts are shifting away from that global competency piece to recognize the fact that, again, it has to be more about decision specific and decision-making ability than more global competency. And I touched on this a bit earlier. So, how we assess capacity, how we define it, this varies even within our own province. That varies across pieces of legislation, and it certainly varies across other jurisdictions in Canada. But it's always an effort, and it's certainly through the 5-year review of not reinventing the wheel. Learning what works well in other jurisdictions and seeing how that's applicable in this particular context. I was part of a presentation a while ago, and someone was joking about research and development. And they said really the R&D stands for rob and duplicate. So if there are things that are working well somewhere else, then let's think about what may work here. Steve, anything to add on that one before I hand it back to you?
No, I think you touched on it all, Henry. I think, like it kind of says there, I think really our clinical and or legal requirements could be different depending on sort of that area that we're operating under, essentially.
Yeah, absolutely. Okay, I'll pass it back to you.
Awesome. Okay, so just some key concepts for capacity, folks. So as Henry alluded to in the last discussion, so capacity is now recognized in adult protection to be more decision specific. So it's recognized that, for example, capacity can exist in one area in respect to one decision, but not another. For example, an adult may have the ability to make some personal healthcare decisions, however, may lack capacity in respect to some financial decisions. Or someone may have the capacity to manage their finances, but may lack capacity in areas, for example, related to independent living, for example. So we're really looking at what is the person's ability to understand and appreciate their ability to make a specific decision at a specific time. So that is a big shift in practice, and I think it's still ongoing and sort of evolving across different areas and professions. In line with that, the capacity assessments under adult protection are also decision specific. So usually a risk has been identified in a particular area related to a particular decision. And that suggests an adult, for example, maybe in need of protective intervention, and the assessment could proceed from there. It should also be noted that under Section 6.3 of the Act, I believe it is, if a person is found to lack capacity in one area, they are still presumed to have capacity in respect to other decisions. So if an individual was found to lack capacity in respect to some financial decisions, for example, they would still be presumed capable in other areas until proven otherwise. And it's also recognized, folks, that capacity is on a continuum. So as Henry alluded to, it's not this all or nothing type, on or off type binary concept. It's recognized that there's more, like, I guess we would say, degrees of capacity, and folks can be more or less capable in respect to particular decisions. And Henry made the great example of the light switch and the dimmer. I think that really captures that concept really well. And it's also in respect to, that because capacity is fluid. So not only is it decision specific, but it's fluid. It can change. It's not something, I guess, that you would acquire and is fixed. And it's sort of in that spirit, I think, that not only can capacity be reassessed, but as we touched on, adults that are declared have those safe service plans consistently reviewed to ensure that any changes in capacity are sort of met with changes in the person's status, we'll say. Another big piece to remember too, folks, is that capacity is not defined by a diagnosis or disability. For example, an individual with a severe mental illness or a cognitive impairment could potentially have challenges understanding and appreciating particular risk. However, that diagnosis does not imply this or mean it can be assumed. And much like the concept, I think, of decision specific, I think that's an evolving area. So as we highlighted in some of those points earlier, I think there is a tendency to think that if someone does have a cognitive impairment, that, for example, their decision-making is automatically in question. So a person, for example, develops mild dementia, and the ability to make that decision immediately comes into question. However, I think it's recognized that, we should hold on. Just because someone receives such a diagnosis does not mean that they lack capacity and are unable to make those decisions. And while the diagnosis or disability, of course, will inform an assessment, its presence is not grounds for determining that someone lacks capacity. And folks, capacity may also be influenced by temporary factors. So, for example, a person could be suffering from delirium due to a UTI, or could be experiencing, could be impaired, for example, due to substance use, or could be impacted by the time of day, or even a lack of sleep, for example. So there are a number of, I would say, temporary factors that could impact a person's capacity. And in adult protection, these factors, we always say, should be resolved to the best of our ability before proceeding with the assessment. So if there were adult protection concerns with an adult who was experiencing, say, a form of delirium from a UTI, for example, the UTI would be stabilized before proceeding. And again, that's in recognition that those factors could impact a person's capacity. And finally, folks, as we noted in previous discussions, capacity is very much like a clinical and legal concept, we would say. So it's not necessarily like a diagnosis, for example. So there's no, we'll say, magic formula where, there's sort of a checklist of symptoms that we can check kind of quantitatively to determine a person's capacity from that. It's very much intertwined, I think, within the context in which a person lives and a person's values and preferences. And as a result, it's ultimately, I think, the clinical judgment of the assessor informed by an understanding of the adult and an assessment that ultimately would determine capacity at adult protection. Any other thoughts there, Henry?
No, it is important to remember that it is fluid, and even, you know, within a disease process itself, you know, dementias evolve, Parkinson's disease evolves, and that can have a very fluctuating impact on someone's capacity. So it's important, you know, if an adult is engaged in a capacity assessment, it's important that assessors are catching them at their best. So if someone's coming to see me to talk about my decision-making ability, and I know I'm really, really bad in the morning and I'm not myself until the afternoon, well, that's an important consideration. So getting guidance from the adult and also maybe those who are, you know, part of the adult circle of care or family, when to best do that. So that's good. So this may be more relevant to practitioners, but I think it's helpful for all of us to think about, you know, capacity assessments and why we'd even go down the road of assessing capacity. So as Steve pointed out earlier, and as we can imagine, capacity assessments can be very intrusive. So one of the potential outcomes, if I'm coming to talk to you about your decision-making ability around where you're going to live, and you don't do well with that assessment, then you don't make that decision. And that's not to be, you know, callous, but that's, you know, kind of the reality based on the risk. So in adult protection, the valid trigger or why we'd even question someone's capacity is risk. So there's something that the person is doing to put themselves or others at risk, and we are not sure if the person really understands or appreciates that. So we really need to be sure before we're going to go down the road of a capacity assessment that there is a valid trigger, right? And we see some examples listed there. So before I assess someone's capacity, have I exhausted all of the other options to mitigate risk? You know, sometimes if someone has a diagnosis of dementia or some other type of diagnosis, families or caregivers sometimes are quick to ask for a capacity assessment. Well, let's hurry up and assess that person's capacity because we're not sure what they're going to do about, you know, such and such. But until there's a presenting risk and a reason why we'd even question them, we really need to come at it from the point of autonomy and presume that they are capable. And none of us would expect any less. So, you know, if we can think about it, like what would it be like if someone came to us and said, look, we know you've always made this decision for yourself, but we don't think you can do that anymore. Like, how frightening must that be? So we do need to tread very lightly. One of the service principles of the Act is the idea of being least intrusive. So if we do need to intervene, particularly if we need to intervene involuntarily, what's the least restrictive way to do that? You know, maybe it's addressing the risk with some home support. Or maybe it's addressing the risk with having the public trustee look after someone's finances. You know, if someone doesn't need, for example, to be institutionalized, let's not do that. So we need to think very much, you know, what are the options available? And a really good question to ask ourselves is the intrusion of the assessment proportional to the risk? So does this risk warrant us going down the road of working with this adult with the potential outcome being taking away that adult's right to make that decision? So a lot of serious questions to ask ourselves. And as my mother would say, a lot of tall thinking to be done before we'd actually engage in this process. Steve, anything to add before I move to the next slide?
Maybe just one point. I know, and just I think it's kind of come up in cases before, that this idea that the risk could be related to maybe there's a significant change in a person's behavior that doesn't necessarily align with their preferences and values. So for example, if you came across a case like that, it was an individual that was at severe risk due to, say, they were living in just severe squalor, for example, and you know, it was just a serious situation. this could occur to someone that at some point folks' collateral sources could indicate, for example, that took great care and pride in their home before, or you speak with collateral sources and you say that something has really kind of changed with the person, that there's something really different. They're just not, they don't seem like the same person anymore. I think that's a common, major red flag / trigger that we often see in adult protection. So just thought it'd be helpful to kind of, touch on that.
No, that's a good point. And it gets back to the right that we all share to live the lives that we want to live. So, unless it's a serious deviation or something that's really out of character for someone, sometimes that can be, like you said, a flag for that. Some of the other things that we think about before we'd engage someone in a capacity assessment, what is it I'm actually assessing? So again, what is the trigger? Where is the risk identified? So if it's around your living arrangement and the ability to live independently, for example, why am I necessarily asking you questions about your finances or how you manage your medications, right? So it's more specific to the question or the issue at hand. And even if, again, we find that an adult is lacking capacity in one area, our care plans and our court documents and our assessments and our documentation all need to reflect the fact that it's only incapacity in that one area. And that doesn't mean the person doesn't have decision-making ability in other areas. Important as well to think about my own values in relation to risk. And that just doesn't go for clinicians. I think it also goes for members of the general public. And when we think about, should I make a report, or, we all have that moment when we look at someone else and think, oh gosh, I wouldn't do that, or they shouldn't do that. But that's really our own personal risk threshold speaking. So, and what may be good for you may not be good for someone else. So it's important to reflect on, do I not think this person should be doing that because I wouldn't? Is it more of a personal judgment on my part, or is there a legitimate concern here? Have I informed the adult? So again, this gets back to the idea of informed consent. And again, I'll reiterate, none of us can be expected to make an informed decision without the proper information. So it's very important, and for any of us who have been on the service receiving end with a health professional, it's important to make sure that consent is actually informed and that you're getting your questions answered. And what can I do to ensure that the assessment is valid? How am I involving that adult? I talked earlier about supporting capacity while also assessing capacity. So how is it I'm helping to facilitate good communication here? Are there supports or services or other individuals or other things or another setting that this person needs in order to be able to communicate appropriately and effectively? And that can be difficult sometimes. In our very busy and overtaxed healthcare system, sometimes it's hard to pump the brakes and to slow down and to take the time to do that clinical assessment and to facilitate those supports and to ensure that the person is being heard. But it's certainly a service principle that's fundamental to the Act. Steve, anything to add before I go to the next one, or before I hand it back to you?
No, that's great, Henry.
All right.
3 points.
All right, back to you.
So how do we, formally assess capacity under APA? So in adult protection, we use an interdisciplinary process. So under the adult protection regulations, there are 7 professions that are identified as being able to assess capacity under the Act. So this includes social work, speech language pathology, nursing, physiotherapy, psychology, occupational therapy, and medicine. So this process is used because I think it's recognized that the best capacity assessment is, a thorough one involving the adult and a team of professionals. And we'll kind of touch on this process in greater detail in the next slide. But important to note that the process is really in recognition that, all professionals really have an important role to play in assessing capacity under the Act. So depending on the risk and the situation, any one or more of these professions could play a vital role in determining a person's ability to understand and appreciate a particular risk. And this is definitely a new approach for assessing capacity in the province, and then has not been without challenges, we would say. But I think the process itself can be very beneficial, particularly if we think about capacity with that more holistic lens, we'll say, where these multiple professional perspectives can kind of really enrich the process and ensure that we're getting a comprehensive view of the adult's capacity.
That's a good point, Steve, because again, it's a relatively new approach. Of course, the interdisciplinary approach is not new, and decision-specific capacity is not really new, but I think putting them together is relatively new. So understandably, there are some growing pains with that. And again, we're all on that learning curve. And one thing that we heard loud and clear through the 5-year review is that there needs to be more consistent, accessible, and robust education for all professionals across disciplines. So Steve and I have already started that process. How do we engage professional associations and colleges? How do you engage schools and students in this process? Because again, it's an underlying concept that will touch any and all lines of business and practice that we would get into.
And so, folks, as we noted, it is an interdisciplinary process, and the process, where possible, is coordinated by a social worker, for example. So the social worker really plays a dual role in that process. So they're responsible, of course, for completing their own assessment of capacity, but they're also responsible for coordinating the assessment. So generally, before this process begins, as we kind of touched on, a risk will have been identified, and all options to kind of mitigate that risk have been attempted. And the social worker would then identify the appropriate professions to include in the process, which of course will be dependent on the area of risk. So if there were risks around, for example, particular areas of independent living, the social worker may reach out to an OT, medicine, and physiotherapy, for example. So that team will come together and sort of clarify the decision or decisions of risk to be assessed, and they would develop those capacity questions. So, does the adult understand and appreciate the risks of, for example, living independently? Each professional then would assess the adult in relation to the decision of concern from their own professional lens. So, for example, an OT could complete a functional assessment. Physiotherapy could assess for the adult for a falls risk, for example. Or, medicine could look at the adult's health status and complete a clinical interview. And social work will complete a clinical interview. So then, following those assessments and a review of the reports, a discussion is held to decide whether the adult is capable of understanding and appreciating the risks being experienced. And then, of course, the team would just work together to develop that strategy for reaching consensus, if a difference of opinion exists, I guess. So, and as Henry alluded to, it's still very new process. Evident that we've only done approximately 40 of these in adult protection. And certainly it's had challenges in certain circumstances, but I think I think it is recognizing that the assessment of capacity in adult protection is a shared one, and it's recognized that various professions can really contribute and enrich that process.
And Steve, just to reiterate, really important that the team agree on the capacity question or questions. So when we all get up from the table and gallop off and get ready to do our assessments, we actually know what it is we're going to assess. So no, that's good.
So folks, every case will be unique, and any determination, of course, of capacity or incapacity is going to look different. But just some things, I guess, to consider when thinking about capacity and incapacities. These are just some, I guess, generalized reflections that might be helpful for folks to consider when kind of thinking about a person's capacity in adult protection. The list, of course, is not exhaustive. But I mean, just some things that we could be on the watch out for, I guess. Can the adult, for example, communicate in their preferred method, of course, and can they communicate that issue and level of risk? So let's say we have this very serious case of self-neglect, and folks come across, for example, an adult who's living with, for example, I don't know, no heat, and there's some windows removed out of the home and no running water, just a risky situation, we'd say. Could the adult, describe what's happening? Could they communicate a recognition of the risk, for example? Can they, communicate with you and with support to indicate that they're talking about their living situation and the risks around that, for example? Or is the adult able to participate in that discussion? Can they have a conversation with you about what's happening? Can they have a conversation with you, about the fact that there's no heat or no running water? Can they have a dialogue with you about that? Or do they ask questions? Do they ask questions that may indicate that they follow and understand that conversation and situation, for example? A good one as well is, can the adult comprehend the information discussed? So does the adult comprehend what we're discussing? Can they comprehend that the heat is not working, or that the water is off, and the impact that could have, and that you're there to discuss that with them? Or is the adult aware of their situation and their options? So are they aware that there's no heat? Are they aware that there's options available for addressing that? And that's really related to, does the adult can be supported, or do they have knowledge to manage their needs? Can they call 911? Can they make a doctor's appointment? Can they call someone to fix the windows and the heat? Do they know how to arrange that? Or can they be supported to do that? Or does the adult, for example, give, consistent or logical answers to the question, for example? So you bring up that you're really concerned with the situation, and they say, well, I don't need heat or running water, I'm superhuman. Or I don't need water because I don't need to drink water. Are the responses, I guess, logical? Are the responses reasonable considering that risk? And one that Henry alluded to earlier, this idea, does the adult reason with the information? Or so in this case, really going back to that decision-making process we discussed earlier. So are they aware of their options and the consequences of their options? Are they accounting for the consequences, for example, of not, in this case, not having heat or not having running water, and those types of conversations? Or another one, does the adult display insight? Does the adult display a sense of self-awareness? So, for example, if a person has a serious risk that is impacting their safety and well-being, are they aware that they have this risk and that the consequences of that risk are impacting them? So, just some general things to consider when thinking about capacity and incapacity. Certainly, every case is going to be very different, and the context is extremely important, I would say, about some of these factors. And one, I guess, closing point on all of that would be that any of those situations would need to be viewed with the lens, I guess, of the adult's preferences and values. So depending on the person, that lifestyle may be in line with the person's way of being or their way of life, which of course would need to be considered before immediately jumping to a conclusion. But if, for example, as we highlighted earlier, if this was someone that was always known to be really, really looked after their home and really always paid their bills on time, and all of a sudden they no longer have heat and running water, then again, that would certainly be something as a trigger or a flag for folks in that process.
And just to add, Steve, very clearly, a lot of these cases raise a lot of ethical and moral struggles and questions, particularly for practitioners and sometimes for family members and people who are trying to support that adult. But it's trying to get at the adult's wishes and respect that to the fullest extent possible. So. All right, so I'll just touch on, we're reaching the end of our slides, and I'm aware of the time as well. Our moderator hasn't pulled the plug on us yet, so that's good. We're still going.
I'm about to, Henry.
Ah, okay.
Okay.
It's nice to
I
have
want
that.
to allow time for questions because I'm sure there will be some.
That's a little advanced care planning on our part. Yeah, look ahead. So some of the FAQs, I think we've touched on some of these frequently asked questions. Of course, capacity, we've talked a lot about that. It isn't, again, up to the report source to determine if that person lacks capacity. But make the call if you do suspect abuse, neglect, or self-neglect. So another issue that has come up, the adult has capacity, but there is risk. So now what? And this was certainly highlighted in the Seniors Advocates Report of 2019 in relation to adult protection. Actually, one of her questions, she raised this in her report. Because unfortunately, we do know that there is coercion, sometimes there's bullying and undue pressure that happens within families or within circles of care, and people end up being either neglected or financially abused or experiencing some other type of violence. It's a bit of a gray area because, again, all of us have the right to accept or refuse service. So it's a very, it's a delicate area to work. But again, it goes back to the nature and the quality of the therapeutic relationship to get at that. We have seen standardized tools, and certainly in the 5-year review, we're gathering those and building those resources into some of the education pieces that we're thinking about. But again, an assessment tool is not an assessment. It's a tool. So it doesn't replace the clinical judgment that needs to go along with. What questions should I ask? We already talked about. And what about other decision-making areas? I think we touched on some of the domains, health, finance, housing, some of those major, when we think about the social determinants of health, I guess we'd think about that. So Steve, I'll pass it back to you for the last couple of slides. Maybe the next minute or so we'll wrap up and then pass it back to Mary for the Q&A.
Sure. So yeah, folks, just a couple of things, I guess, to consider, I guess, from our end moving forward. Cognizant of the time, but just understand and appreciate, for example, that is something that we've seen in other jurisdictions in relation to kind of defining capacity. And a lot of jurisdictions kind of give more attention to kind of breaking down those concepts. So, what do we mean by understand information? What do we mean by appreciate consequences? So definitely something to kind of consider in our context. Same could be said for those procedural protections for adults. I think we really touched on that today. It's so interconnected with, people's rights to make decisions and exercise choice. And this has really been evident across a lot of adult protection cases. And just that final point there, supporting a community of practice. So I think, capacity was such a huge conversation in the 5-year review of the Act. And, really related to this idea is how can we continue to support knowledge development in the area? How can we support the confidence of folks moving forward? And I think the training and resource sharing and some of those case studies are going to be really important and a big priority for us moving forward.
Back to you, Mary. I'll stop sharing my screen maybe.
Thank you so much, Henry and Steve. That was fabulous. And I know that Kelly and Lee have been monitoring the chat. So I would say there are probably some questions in there. And I cannot see either Kelly or Lee. Kelly, do you have a
question? Yeah, there's a question from Julie. Are family members included in the conversations regarding advanced healthcare directives? And are they members of a capacity hearing?
So can't really speak specifically to the legislation that oversees healthcare directives. So it's called the Advanced Healthcare Directives Act. Ideally, if someone is preparing a healthcare directive for themselves, they would involve family and other people close to them in that conversation. So there's no surprises and everyone kind of knows what the person's wishes are, should they no longer be able to speak for themselves. In adult protection, we still try to maintain the family connections as much as possible and appropriate. What we found is sometimes it's the family member or the person providing a service that is the alleged source of abuse or neglect. So maintaining that connection is not appropriate. But so I guess it's case specific.
Yes, and Julie also commented the team approach is great as long as there is not one group being the power holder. I think assessment should include patient and family members too.
Absolutely. And again,
Sure.
It's not just unique to adult protection. All of the health authorities, the Department of Health in the province, it's all centered on the principles of person-centered care. So absolutely, the adult needs to be involved to the fullest extent possible.
No, that's a great point.
Yeah. Lee, do you have a question?
Sure. I see a question here a bit earlier from Fraser Pickle. He says, in keeping with there's a comment and then a question at the end. In keeping with the UN Convention on the Rights of Persons with Disabilities, especially Article 12, and possibly the Charter re legal capacity and the need to provide supports for a person to make an informed decision. So the question is, are you looking at supported decision-making, thus not infringing on the human rights of the person?
I think I think supported decision making, I think at some point needs to be or will be its own piece of legislation or some type of policy direction. But in the meantime, I think through adult protection, we're very much trying to get at what you're raising, Fraser. It's the idea that, you know, all adults do have the right to be heard throughout the process and in the legal process, and the onus being on us then as the system to make sure that they are heard. So while I don't think it's capital S supported decision making, I think there are principles of supported decision making that we're seeing within the adult protection realm and the approach that we've been trying to promote. But more needs to be done. I have no question.
Fraser also put up the link to the UN
Perfect.
Rights of Persons with
Right.
Disabilities.
Yeah, and but it is an important point, particularly Article 12, and it talks about the right for equitable representation before the law. So it does go to the right for an adult who is tangled up in this adult protection process to have the right to have access to and instruct legal counsel. And, you know, there are implications for that as well, for us as, you know, the system and the service providers to make sure that that happens.
Henry and Steve, there's a question from Heather. When can the regional health authorities expect to have access to tools, completing capacity assessments? Recognize this is in the works, but this is greatly needed to assist social workers completing Adult Protection Acts or APAs assessments.
For sure, and that we heard that loud and clear through our roadshow when we heard from frontline staff and managers, police throughout the province, that there really needs to be more education. So the intent is, as we move forward with some amendments to the legislation itself, Steve has been working hurriedly in the background to amend the policies that go along with that. So one of those policies is looking at that team approach to capacity assessment. What does that look like and how do we support it? So yeah, it's coming soon. I can't give you an exact date, but I would anticipate later in the spring, we'd start to see some of that moving. And then following on that, there will be like education and webinars and more of this type of stuff. Steve, anything to add?
No, great point on that person's behalf, and I think just to echo your thoughts, Henry, I think that's will be it was heard loud and clear and for sure in the 5-year review. It was a constant theme, and definitely going to be a big priority, kind of moving forward from that perspective.
Okay, good. There's another question from Glenn. With these teams coordinating, what is the realistic timeline for an APA assessment to be completed? Thinking in particular about rural Newfoundland and Labrador.
It does present its challenges. Oftentimes, particularly in rural and remote communities, we will depend on technology to bring someone in virtually. But and certainly social workers on the front line can speak to this better than I can, but we hear about the challenges of that coordination piece, be it geography or a particular clinician is not familiar or comfortable with the process. They don't necessarily see themselves as part of the process because the approach is so relatively new. So there's been lots of challenges. So the time can vary depending on the urgency of the situation. You know, we've seen capacity assessments happen relatively quickly. It's important.
We're losing you, Henry.
To make a short story long, there's no
Yeah.
set time when that has to happen.
Yeah. We lost you there for a second, Henry.
Okay, am I back?
You're back, but
Okay.
I'm not
Okay.
sure if.
Yeah,
we might
no,
have
just to
lost
say
what you were
that,
commenting.
yeah, just to say that there isn't a hard and fast rule about when it has to happen, but it should happen, as quickly and as thoroughly as it needs to.
Mhm. Another question, Lee?
Yeah, I see a question or a comment as well from Ray. Ray, feel free to unmute yourself if I don't cover all of this. It says it's in the chat bar for others to read. Ray asked, do you see potential of supported decision-making to provide both a higher standard of adult protection without taking away legal capacity? He's speaking of law reform to cover both issues.
Yeah. I don't know if we're going to see as much reform in the amendments to this particular piece of legislation to address it fully. But again, I think we're getting at some of those principles. But to your point, Ray, it's a larger systems discussion and government discussion about, what does supported decision making look like from a legislative or social policy perspective. So I think the question still remains, but I think we're getting at some of it through this process.
Yeah, Henry, can you hear me?
Yes.
Yeah, I think everything is well intentioned here. And I guess one of the unintended impacts here is that if we have to make the decision, not on the basis of, somebody who's in need of protective intervention, and that should happen, and we all agree with that, but the specific barriers that taking away people's legal capacity or keeping that within the legal framework sets people up for a different kind of abuse and neglect, which is the lack of ability to contract, to get medical services, to function as human beings, whether or not they fit into the description of somebody who falls in need of protective intervention.
Mm-hmm.
So there's a wide sweeping impact here of I guess, maintaining the current legal framework, because it directly impacts on the ability of people with disabilities and seniors to live in their own community. So all I would see you guys is, sort of recognizing that you need to continue to do what you're doing, but to embrace the legal reform of, like, can we do this in a better legal framework, which doesn't end up with those negative connotations for people.
I
Thank you.
agree. Yeah,
Right.
no, I agree, Ray, and I support what you're saying. And I think there is a larger conversation that has evolved and is evolving around some of those larger legal system changes that you're talking about. And, it's a conversation that needs to keep happening. But I think it has a lot of momentum right now, particularly in light of, especially in light of, COVID and some of the impacts we've seen in terms of people's rights and being able to, fully participate as citizens in their community.
Is that the last of the questions, Carley and Lee?
Yeah, I think there was a comment from Glenn, if you recall his question regarding the assessment tools and the time frame, especially in rural Newfoundland, Labrador. He commented, so could it take 12 to 18 months or 12 to 18 weeks?
I would like to think it's sooner rather than later. And it will actually
Yes.
have to be, because from a legislative perspective, and we haven't really been told exactly the timeline because our government is sorting itself out there across the way. But once we're told, we could anticipate amendments to the Act being introduced in the House of Assembly in the spring or in the fall session. So, along with that then would need to be those policies and that education piece that supports that. So I would think sooner rather than later.
Okay.
Thanks, Henry. And Mary, I know we're coming up to time, but there's a couple other good questions here that might want some clarification. So Fraser and Julie have both weighed in on this. Is it recognized in the Act that family members and supporters have the legal right to participate, or is it just a courtesy? And it sounds like it's more of a courtesy, not always practiced. So I guess family involvement is the question.
Yeah, a lot of it, again, coming at the point of the presumption of capacity, a lot of that in that informed consent process needs to be driven by the adult. So if the assessor needs to, work with collaborative resources or connect with other people in that evaluation stage, it has to happen with the adult's informed consent. I would think that, any individual, their natural support network is a key part of any assessment. We can't just look at people in isolation. For the social workers on the call, we always love the concept of person in environment. A person is much larger than just themselves. It's, who they're connected with and how they're connected. So any kind of assessment or care plan under adult protection or otherwise should be reflective of the adult and others that the adult would want to include. I don't know if that answers your question or not.
And Henry, just to add to that as well, I would say one of the service principles in the legislation speaks to that the delivery of services under the Act should provide for sort of the preservation of family ties, I believe is the language. And that's a big piece in terms of the process, where folks would encourage that and where they can to the greatest extent possible.
Okay, everyone, I think that's probably it for today. Thank you so very, very much to Henry and Steve. I really appreciate your being here this morning and having this discussion. And hopefully everybody has learned something from it. Next week, we're going to be talking about relationships. We're going to look at common law relationships to married relationships in terms of the law, because they are different. And
Mary, sorry, Mary, were you trying to share your slides? Because we have a blank screen. We have a blank screen.
Yeah.
Just in case you couldn't see what we see.
No, I don't know what you see.
We see nothing. It just says Mary has started sharing her screen.
That's Henry's slides I got up here. I don't know why this is really falling up on me this morning. Okay, we're going to go without the slides. Sorry, everybody. Anyway, thank you so very, very much. And thanks to Kelly and Lee for monitoring the chat. And I really appreciate what everybody has done. Thank you and goodbye. Have a nice week.